Mostly the petitioner hearing was appointed on contractual basis.
Sir?
Appointed on the contractual basis. On the contractual basis in the year 2011. Then thereafter the service of the petitioner was not renewed, extended. Then he filed a writ petition before this honorable court. And the writ petition which filed before this honorable court, page 41, annexure 4, in the motion stage, the single judge passed an order, said that in the meantime, the petitioner shall be allowed to continue and permitted to discharge his duties on the post of assistant teacher on the usual payment. Now, while acting on these orders, the department said, okay, we will continue, we will allow your extensions, and they passed an order, allowed him extensions, and his extension was continued till 2023.
Date of his retirement?
Yes.
He superannuated?
No, no superannuated. Oh. He's continuing. It's a contractual basis. Unless some regular candidate comes, so long nobody comes, then he will continue in the service. Yes. Then immediately the department passed an order saying that there was an order 2/11/2017 passed by the divisional bench saying that all the candidates who are tented, they are not eligible to continue or remain in service. But the question is that I filed my writ petitions on the agreed in 2019, and the government appeared before the trial, before the court, never ever brought this on to the notice of the court that these people are not entitled to continue in the service because of the reasons order dated 2/11/2017. Rather, I was accommodated. I said, okay, the service is extended. I will continue in my service, and I continued my service. Then immediately after the termination order was passed by the department on 1st July 2023, I filed writ petitions before this, before the lower single judge. Where's the page number? This is the page 50.
50.
50.
Yes.
Page 50. This honorable court said, okay, you file a representation, allowing me to file a representation before the department why the service is terminated. And one very important question was asked by the lower single judge: why you have not acted on the order dated 2/11/2017? This order, however, the petitioner was allowed to continue his service even after the judgment dated 2/11/2017. That was the question asked by the court to department. Even after the judgment passed on 2017, I was allowed to continue. Then, this is disposed of, that I filed my representation.
When did you get the interim order?
Interim order I got page 41.
41.
41. This is the interim order.
For 2019.
2019. And the department allowed me to continue and pass an order. So I was allowed to continue in the service.
So, on the face of this order, you should not have filed the writ petition at all.
No, I filed the writ petition on being aggrieved by the order of terminations. The order of termination is what's in page.
See, it is only a contractual appointment, is it not?
It's a contractual appointment.
So, you have been given work for a particular period. And it is not a proper recruitment. No recruitment process.
That I agree.
Yes.
Yes.
And what is your right to continue?
No, forever. Lordship, the right to continue, I am not claiming my right that I should be allowed to continue. If any regular candidate comes, I will be ousted.
So, till such time regular candidate is appointed, you must be permitted to continue.
That's not my case only. So, Lordship, the page 49, is the order passed by. This is the only ground given by the state respondents, page 49. Page 49 says, they passed order in 2023, well, the order was passed in 2017. He said, in pursuance of the order number DSEL ELGA APP whatever, dated 31st May 2023, issued by the directors, School Education and Literacy Meghalaya, in view of the letter, so and so, the Joint Secretary of the Government of Meghalaya Education Department, as well as in conformity with the directives issued by the Honorable High Court dated 2/11/2017, the service of the tented teachers of three so and so are terminated.
Yes.
So that is the only ground taken by the
1st July 2023.
23. So, but they are now acting. The order dated, on the basis on which I was terminated, is the order dated 2/11/2017. But when I filed the writ petition in 2019, it was never brought before this court that this is the ground where I will be terminated or I would not be allowed to continue. 2019, even thereafter also I filed.
See, whether you are at mistake or the respondent is at fault, there is an order of this court dated 2/11/2017. 2017. Pursuant to that, no person can be appointed on contractual basis.
No, this order says, because there was some recruitment process, there was a to the High Court has come to
This
the
is
conclusion.
backdoor entry. If this is going to be allowed, every person will come before this court say that I must be allowed to continue.
No, see, the ground taken by, here the case is a little bit different. There was selection process. The Honorable High Court said those people who participated in selection process, thereafter they found tainted in the CBI report. So I am not remotely connected with the CBI report. My case is not on that. Because pursuant to that selection process which was declared null and void, I was not appointed. I was appointed in 2011. I continued till 2023. One fine day they said, this is the order. It is this order also applicable to you also. But I say this order is not applicable to me. Because I was not appointed pursuant to
that is the order dated 2/11/2017. Where is the order?
That is the order. The government never placed before the court this order.
You are relying upon this order. It's there in order.
No, I am not relying on this order.
No, you are referring to that order. Relying means you are referring to the order.
That is the.
See, according to you, this order dated 2/11/2017 was not brought to the notice of the court when your matter was heard.
In 2018.
Number two, you have been allowed to continue on the face of the order dated 2/11/2017.
Yes.
Correct?
It's
So you must be allowed to continue till such time fresh recruitment takes place.
Please.
That is the sum and substance of the argument. So we would like to know, where is the order dated 2/11/2017?
No, see, the order was never brought before the learned single judge by the government. The government is relying it. The government has never brought this order before the learned. We are just hearing. So after being agreed these orders, again I filed writ petitions. Let's say again I filed writ petitions, and it was disposed of on. It was disposed of on. It was disposed of on 20/11/2023, page 73. I am agreed with this order only. I am before this lordship against this order. The impugned order is Annexure 2, page 73.
In page number 76.
Page number 76, Lordship.
You are the petitioner, one of the person involved.
Because we are pursuing
Number
the
D.
first party.
Clause number D.
As per CBI and HSC report, there are 10 candidates, Datingri, who were declared tainted. This is the ground, Lordship. I'm saying that when I filed a writ petition in 2019, they never brought this before the Honorable Court, saying that this is the ground you cannot continue. Rather, they said they passed an order, accommodated me, and they said you can continue. I continued till 2019.
Right. The subsequent writ petition, this has been brought to the notice. The learned single judge has relied upon that and extracted it in page number 75.
Relied upon, this is there are two grounds I have taken. Before this
What are
order,
the two grounds you have taken?
before this order, learned single judge has allowed me to file representations. To file a representation, page 50, the 50 is the judgment, whereby the learned single judge has said to file a representation before the departments. And one very important question asks, why you have not acted the order dated 2/11/2017?
Correct.
That is not answered by the petitions. The representation we file, we have taken two grounds. We are saying we are not remotely connected with the selection process, whatever the decision taken by the Honorable Divisional Bench. And secondly, said why I am selectively targeted. Because in my representation dated 58 is a very elaborate representation filed before the department. If you are saying I am permitted to read.
Yes.
With due respect, I am submitted that this representation to you with the following facts in pursuance of the judgment and order dated 22/8/2023 passed in WPC number 253/2023 by the Honorable Court of Meghalaya. My appointment to the post of assistant teacher of Lower Primary School was done on the contractual basis by letter number 16 June 2011 against the vacant post in Singimari Government LP School in the scale of pay so and so and rules that I have been in continuous and uninterrupted service as an assistant teacher in the school, that is with effect from 11 till date, and the performance of the petitioner as a teacher in the said school has been found satisfactory. It may be mentioned herein that during the service as extended from time to time, that it may be mentioned herein with my salary was withheld for the month of July 2019 till November 2019 at the rate of 29,905 per month. Therefore, I, on being aggrieved by the said action, approached the Honorable High Court by way of writ petition being WPC number 531 of 2019. This Honorable Court, on being satisfied, passed an interim order dated 4/12/2019 in my favor. Thereafter, I was allowed to remain in service in compliance with the order dated 4/12/2019 passed by this Honorable Court in WPC number 530 of 2019. I had withdrawn the said writ petition after my grievances was redressed. That my service was extended from time to time so as to enable me to continue as an assistant teacher in the said Singimari Government LP School since the year 2011. I was still in service and I had been performing my duty with utmost sincerity, diligently. However, I received great setback when I came to know about the order dated 1/7/2023, whereby my service was shown to have been terminated on the ground that the Honorable Court passed an order dated 2/11/2017, and I am treated as a tainted teacher. It may be mentioned herein that I am the teachers appointed
You
on
don't read the entire thing. You can it suffice. You say the nutshell if you put it.
then in the same paragraph, Lordship, para 17. Para 17 of my representations.
Para 17.
17 years. He said, I feel that myself and few others have selectively terminated by order dated 1/7/2017, whereas most of the candidates whose name are figured in the list submitted by CBI, who are the tainted teacher, but surprisingly they have been continuing in service. It is found mentioned in later number. Then we have produced the name of those teachers. This is my representation. If the department want to consider, they should consider both the aspects.
Two wrongs will not make a thing right. Merely because some persons or tainted have been allowed to continue, they may take action. We do not know. Merely because you have committed a wrong, you say he has committed wrong, I have committed wrong, so I should be continued because he is continued. That cannot be a ground.
No, government, the question of discriminations
So you see
If the government-
equality and illegality.
But that representation, the government disposed of my representation by passing an order, but that was not answered. This question was not answered by the government. If the government said, yes, I have answered these questions, the matter ends. But government has not answered. Government simply relying the judgment, quoting from the judgment, paragraph 1 A, B, C, D, and from there, in view of this, here I am not entitled. So the order passed by the government is not a reasoning orders, not a speaking order at all, not
See, you have been selected for permanent appointment. Because of the CBI case, you have been given work on contractual basis. And CBI have come to the conclusion that you are a tainted teacher. And some other, including others. And action have been taken against some persons. Some persons are allowed to continue or continuing is your contention. We need not go into that. As long as the report of CBI is intact, has not been interfered with by any court, then you have no progress to continue.
But Lordship, this appointment was this appointment.
Teacher's post.
But Lordship, I lost my livelihood because I am having children. I am the persons where I am going now. So now, if I am allowed to continue in the service, so unless some regular candidate comes, it will suffice the purpose. The government should not have acted such a harsh
Probably
decision.
they may think that you are continuing, they are not recruiting. If they send you out, they may recruit.
They have not done till today.
They may do it.
They have not done it till today.
Sorry, come. The present appeal has been preferred against the order dated 2011-2023 in WP 363 of 2023. The case of the petitioner is that, how many petitioners are there?
Only one person.
Only one petitioner. The case of the petitioner is that he is an assistant teacher of lower primary school appointed on contractual basis in Singimari Government LP School. Full stop. The contractual employment was discontinued by an order dated so and so. Agreed by the proceedings, the present writ petition has been filed. The writ petition has been filed, and the learned single judge has not granted the relief on the ground that the petitioner's representation, writ petitioner's representation have been considered in detail, and that as per CBI and HLSC report, there are 10 candidates who have been declared as tainted, and the present petitioner is one among them. According to the petitioner, the services of the petitioner have been disengaged by means of the impugned order dated 1/7/2023, relying upon the orders of this court dated 2/11/2017, which was not brought to the attention of this court earlier. Full stop. The petitioner has knocked at the doors of this court for justice, and that this court, by an order dated 22/8/2023, permitted the petitioner to make a representation narrating the grievance and the factual and legal submissions available to him, and that the representation may be considered by the respondent in the writ petition 253 of 2023 within a period of 4 weeks, in case the representation is filed within 2 weeks from the date of register of the order. He would further contend that there is a reference to the order dated 2/11/2017 by the learned single judge, that the said order was not brought to the attention of the parties concerned. Full stop. You also drew the attention of this court to the earlier order in interim order in WP 531 of 2019, dated 4/12/2019, directing the authorities to continue the petitioner to discharge his duties in the post of assistant teacher on usual payment. Full stop. According to the petitioner, the appellant, the order of termination is arbitrary and discriminatory, and that as long as the regular recruitment has not been done, he may be permitted to continue in the service, and the scope of the prayer in the writ petition, which has been negative, is also for a limited prayer. Full stop. A reading of the order impugned in the writ petition and the order of the learned single judge would make it very clear that the representation has been dealt with in detail, and based on the advertisement dated 10/12/2018, the petitioner and others have been selected for appointment to the post of assistant teacher in government lower primary school. Full stop. Since after the based on a complaint against the selection process, a detailed inquiry was conducted by the CVI on the direction issued by this court, and irregularities have been detected. Since the petitioner, the appellant, is also one among the person who has been declared tainted, the relief was not granted. Even though the petitioner has brought to the attention of this court to the earlier orders of the court, after the order dated so and so, the interim order gets merged, and this court has directed the representation of the petitioner to be considered, which has been considered in accordance with law after due opportunity to the petitioner. In view of the extract made by the learned single judge from the proceedings of the respondent, second respondent, dated 26/9/2023, which is reproduced here, we are of the view that the petitioner is not entitled to the relief sought for in the appeal, and appeal is dismissed. No cause.
Item number 2.
Lordship, here the item number 1 and item number 2, the facts are more or less similar. Only the difference is that, Lordship,
Sir, item number?
that one just now that my Lordship has disposed that matter.
Oh,
Because in item number 1, the petitioner was dismissed relying on the judgment in order dated 2nd November 2017, Lordship. And I am seeking the benefit. My rights have accrued from the judgment dated 2nd November 2017, Lordship. What happened, Lordship? In the year 2008, Lordship, the government of Meghalaya has undertaken the process for recruitment of appointment of assistant teachers in government school, Lordship. Then in the selection process, Lordship, the petitioner has participated,
so
Lordship.
you're also placed on par with the first case.
Yes, Lordship. But only the difference is I was unsuccessful, Lordship.
You are?
Unsuccessful candidate in the selection process, Lordship. Then the selection was challenged before this honorable court. Then the matter traveled up to Supreme Court. Finally, the division bench of this honorable court has disposed of the matter by judgment that was 2nd November 2017, Lordship. The operative part of the judgment, Lordship,
See, when the entire the selection has been held to be bad, based on the CBI report, what is, whether you are a successful candidate or not, what does it matter?
While cancelling this selection process, Lordship, some liberty was given with regard to some unsuccessful candidate, Lordship, because the unsuccessful candidate has challenged this selection process, Lordship, because their prayer in the writ petition was that if they are out based on the CBI inquiry and if we are eligible, if our case is to be considered or come within the zone of consideration for appointment, then I should be allowed. But that prayer was dismissed. The prayer was rejected.
What is your prayer in this writ petition?
Lordship, kindly come to page, Lordship. 15, Lordship.
15.
15, Lordship.
Yes.
And
Yes, sir.
And before that, Lordship, if my Lord kindly see para 1 of page 14, Lordship, of the judgment, Lordship.
Para?
Page 14, Lordship.
14, yes.
Yes, Lordship. The short question raised in this appeal arising out of the rejection of the writ petition filed by the appellant herein is as to whether the writ petitioner fall within the purview of clause 1C of direction contained in the division bench order of this honorable court dated 2nd November 2017. The clause, Lordship, that is at page 15, Lordship.
15.
15, next page, Lordship. Clause 1C.
1 minute. Ragman, previous case, give him the judgment of the Supreme Court with regard about the teachers. Yes. Yes.
Lordship, para 3, Lordship.
Para 3.
Para 3. This is the direction, Lordship.
Yes.
The principal directions which are relevant for the present purpose are contained in the several subclause of clause 1 of order dated November 2nd, 2017. The whole of selection process under the advertisement dated 10/12/2008 as issued by the Deputy Inspector of School in pursuant to the notification dated so-and-so is held vitiated in relation to Shillong, Sodor, Zuai, Amlagan, Pura and Dadangiri centers and is annulled subject to the proviso that only the candidates who have been treated as untainted, unblemished both in the reports of CBI and SLHC and are in service may be allowed to continue as stopgap arrangement until fresh selection takes place. The prayer of other tainted, untainted, unblemished candidates of the said five centers for induction in service is on rejected. Our prayer, Lordship, for induction in the event if they are out in the service, then if we come within the zone of consideration for appointment, then direction may be given to appoint us. That prayer has been rejected, Lordship. And while rejecting, my Lord, however, Lordship, see, Lordship.
If you are untainted and unblemished candidate, you are entitled to participate in the
Yes, Lordship.
Yes. According to the counsel who appeared in the early matter, selection has not. So when are you going to have the selection, sir? 2008 notification.
Made this is your Lordship. Lordship, in fact, your
Nearly
Lordship.
17 years have gone by.
No, now the selection process is going on, your Lordship, because
When? How long?
2008, your Lordship, that has been voiced by the honorable, by the dishonorable court, your Lordship, on being challenged by some unsuccessful candidate, your Lordship. CBI inquiry has been ordered, your Lordship. That was the order that.
That is right. That has come to a close.
Lordship, yes.
Because no person can be appointed from that selection.
Correct.
So you have to issue a fresh notification and commence the process of selection.
That is going on, your Lordship.
Going on means?
It's being done, your Lordship.
My Lord, come to that.
When was the CBI submitted the report? When did the CBI submit the report?
Lordship, the CBI submitted the report sometime in the 2017, your Lordship.
2014.
13, 14.
2014, your Lordship. Yes.
A decade has gone by, 24.
Lordship, so far this misapplication is concerned. If Lordship kindly come to the course title, this is He has sought the permission of this honorable court, your lordship, by means of a misapplication in a dispute writ appeal, your lordship, to allow him to take part in the selection in the
Correct.
personal interview
See,
5/1/2024.
now the
Let me kindly see.
we'll pose a question to you.
Lordship.
The only issue in this writ petition, which is now subject matter of appeal, is that whether the writ petition falls within the purview of clause number 1C. That is only prayer. Based on this clause 1C, which is at page number 15, the candidates who are untainted and unblemished can be considered
For
for the
Taking
selection,
part in selection process,
part in the examination.
lordship, yes.
See, now they will be overaged. After 10 years, many would have overaged.
Lordship, what I would like to bring your lordship attention is kindly see the cost title, your lordship.
Plus,
Clause title.
what title?
Lordship, yes. Lordship, this is a misapplication, your lordship, in the dispute writ appeal.
Where's the clause title?
Lordship, kindly see
Participate in the personal interview for appointment of government employee scheduled on 5/1/2024.
9/1, your lordship. Now we are in February, your lordship.
So according to you, by looks of time, the relief cannot be granted.
Lordship, the personal interview must have been completed by this time, your lordship.
Do you agree that he is not an untainted person? Is clean records? Is an unsuccessful candidate in the earlier examination?
As per the judgment of the division bench, your lordship, yes, your lordship.
That reflected.
So, then why don't you consider? See, now we require teachers. See, you are not recruiting. You say that persons who are tainted will not recruit. The persons who have got clean records also will not select. How can you do that?
Lordship,
How can an institution
let me have instruction, your lordship, as to whether so far this particular area, whether the selection process had been completed or not, your lordship. Because it appears, your lordship, that there was a personal interview on 5/1/2024 and 9/1/2024, your lordship. So by this time, lordship, it may have been completed, your lordship.
interview would have been over? Interview is over.
Lordship, because as per the application, your lordship, 5/1/2024, 9/1/2024, your lordship. Now we are in February, your lordship. It must have been completed, your lordship.
Please answer our question.
Lordship,
After the cancellation of earlier selection, whether there was any advertisement.
This was the first lordship.
Advertisement was there.
yes, your lordship.
So selection process took place.
Lordship, yes.
The only interview was to be held.
Lordship,
So, was he a successful candidate in the subsequent selection examination?
lordship, it appears that we'll have instruction, your lordship. Whether he took part in the selection in the present selection or not, your lordship.
No, he said in the earlier selection he is not selected because he failed candidate.
Lordship,
Not a
yes, that is-
successful candidate.
that is correct.
Now in the selection, the subsequent selection, he got selected in the written examination. To conduct an
That
interview.
I'm not aware. I'll have to seek
So my
instruction.
lord,
Because you only asked us to read the prayer portion.
I'll have to seek instruction, your lordship, whether in the subsequent selection process, whether the petitioner took part or not, that I'll have to take instruction, your lordship.
Get instruction and report on Monday.
Lordship.
Unsuccessful. Have you participated in the subsequent examination?
my lord, kindly see para, if my lord, I may repeat para 1C, lordship. Para 1C, where I am claiming my rights, my lord. However, all the untainted, unblemished candidates of the 5 centers, whether in service or not, whether in service or not, shall be allowed to participate in the pre-selection process, if otherwise eligible in accordance with the presently applicable rules and guidelines, without necessity of their applying afresh. In this regard, it is also provided that none of such untainted, unblemished candidates shall be treated as barred if he was within the age prescribed by the notification dated 24/11/2008, Lordship. Now in the year 2021, Lordship, the respondent has advertised the post.
Respondent?
The state respondent has advertised the post for fresh selection process, Lordship. Now in the new recruitment process, Lordship, they put the extra qualification, that is the Meghalaya teacher's eligibility test, Lordship, that made mandatory. But as per the judgment, I was claiming that since I was eligible,
You were eligible at that point of time.
at that point,
Now, as per the amended rules, you are not eligible.
not eligible, Lordship. That is why I came before this honorable court, and this division bench has clarified that my qualification will be applicable as on when the judgment was passed, Lordship. Now, 2017, the eligibility criteria for appointment of LP teacher I have enforced, Lordship.
So that has changed.
Not changed, Lordship. When the judgment was passed in 2017, the eligibility criteria for appointment of LP teacher was SSLC and diploma, DLED. Now in 2021, they have changed, Lordship.
That's what is the change?
Yes, Lordship. My contention was the since
What is the present qualification as per 2021?
the educational qualification is same, Lordship, but only that I have to obtain the MTET, Lordship, Meghalaya teacher's eligibility test. The rest is same, Lordship. That is why the judgment.
This is the order of the court.
Yes, Lord.
Para number 1C, which you are referring to, is the order of the court.
Yes, true, Lordship.
That has become final.
Yes, Lordship.
The court has given age relaxation.
Yes, Lordship.
The court has also said you are eligible to participate if you are untainted, or if you are not an untainted or unblemished service, you are entitled to participate. What the condition stipulated is you must satisfy the present rules and guidelines.
The present rule and guidelines, that was in the year 2017, not 2020 and 2021, Lordship. That has been clarified.
But
My Lord, that is the issue, Lordship. Next page, I may be allowed to read the entire judgment, Lordship. Page 16, Lordship. The relevance of clause went on to clarify that the unsuccessful but unblemished and untainted candidates at the 5 centers would be considered in course of the fresh selection process, irrespective of whether such candidate at the time of selection were age barred. As it evident from the relevant direction, the unsuccessful but untainted unblemished candidates at the 5 centers were not even required to apply afresh. As per the relevant direction, their candidates would automatically have to be considered. The only caveat to the relevant direction was that such unsuccessful but untainted and unblemished candidates at the relevant 5 centers have to have the requisite qualification to be offered the appointment, and the qualification would be reckoned as on the date of the judgment. It may be observed in this context that it was open to the appellate court to allow all the candidates who were qualified to participate in the 2008 selection process to be eligible for consideration in the first selection process, but the division bench consciously shrunk numbers of candidates would have to be eligible to be considered for the first selection process by issuing of the words if otherwise eligible in course with the presently applicable rules and guidelines. In other words, if the essential qualification for the post is to alter between 2008 and 17, it would be the altered qualification relevant in 2017, which would be the best benchmark and not the extant qualification of 2018. The interim order dated 16 December 2021, the reasoning furnished for rejecting the present writ petition is found at para 7 thereof. I am not going to that, Lordship. Para 8, Lordship. It is the third sentence of the relevant paragraph which appears not to be in consonance with the appellate court order of November 2nd, 2017, particularly direction contained in clause 1C thereof. The direction contained in the relevant appellate court order cannot be understood to have afforded an opportunity only to those candidates who lost their post despite being selected. Clause 1A is confined only to those candidates who were selected and were found to be untainted and unblemished. However, clause 1C is explicit in the use of the expression all the untainted, unblemished candidates of the said 5 centers, whether in service or not, such persons shall fall within the purview of such quoted expression have been allowed to participate in the fresh selection process, subject to such persons being eligible for consideration according to the rules and guidelines applicable at the time of delivery of the judgment in 2017.
Yes.
So, my lord, what was the relevant?
So the qualification applicable on the date of judgment alone will have to be taken into account.
Yes, Lordship.
2017
17.
and not subsequent amendment.
Yes, Lordship.
What is said to that, sir? Because even though clause number 1C has categorically stated that if otherwise eligible with the presently applicable rules and guidelines, it is on the date of the judgment. If any amendment has taken place subsequently, it does not be put against the petitioners.
Lordship, let me have instruction, Your Lordship. Let me have instruction, Your Lordship, in the matter.
Monday,
Let it be on Tuesday, Your Lordship. Tuesday, Your Lordship.
Tuesday.
Lordship.
This is only point.
Lordship,
See,
yes. Lordship,
see, they have got clean records. Only thing is the unsuccessful candidate.
Lordship.
The unsuccessful candidate, they know adverse remarks against them. Then the judgment says age relaxation should be given. Apart from that, the qualification of, prescribed as on the date of the judgment alone should be taken into account.
Lordship,
If
right.
any amendment is going to be there, that not be put against them. That's one aspect. Number 2 is that you said that the interview is already been over.
Lordship.
First you ascertain
I'll have to ascertain,
the selection they have got
Lordship, I'll have-
successful and whether they participate in the interview. Otherwise, we'll fix a date for them to appear for the interview. And how many candidates like the petitioner are there? Because it should not open a Pandora box.
Lordship, because it appears, Lordship, that he took part in the selection process of, but he did not come out successful, Your Lordship. That is why he was
The
not
earlier one or the present one?
the earlier one, Your Lordship, the earlier one.
On the present one, he has to participate in the examination.
Lordship, let me have a specific instruction, Your Lordship.
See, if he is a failed candidate, he can't say I was given a posting. So he has to take part in the examination.
Lordship, let
And
me have instruction.
whether a failed candidate or a person who has passed the examination, for all the selection process, earlier selection process is gone. They have to participate in the written examination based on a notification issued subsequently.
Lordship.
But for those candidates who have participated in the regular examination based on the notification 2008,
8, Your Lordship, yes.
age relaxation should be given
Lordship, yes, that is the judgment of the Honorable
and they
Court.
must be allowed to participate based on the qualification applicable as on
At that particular time, Your
2017.
Lordship, yes.
That's all.
Yes, Your Lordship.
Yes. Post
On Tuesday, Your Lordship.
Tuesday.
Or Tuesday. Highly apply, Your Lordship.
PV list, item number 1. Item number 4.
Come to paper book. The usual one. Oh, no, it's not us.
But please, Lordship. Lordship, this is an appeal. Lordship, this is an appeal filed against the rejection of a bail application by the Special Judge NIA Shillong. Lordship, while preferring the appeal, there has been a delay of 113 days. The appeal has been filed under Section 21 of NIA Act. Lordship, and therefore we have filed a misapplication for condonation of delay. For the condonation of delay under limitation.
Delay, I think, has a condone. Not.
No, yes, Lordship. Lordship,
We have filed an
the,
objection to the
Yes.
application for condonation of delay. We have filed an objection to the application for condonation of delay, my lord.
Where is the objection?
My lord. My lord, our primary objection is, my lord, in terms of the NIA Act, the maximum period is 90 days, my lord. And delay beyond that cannot be condoned, my lord. If lordship kindly take up section 21 of the NIA Act, my lord.
This one, 103. Yes. 1, 2, 3 alone. Which one? This one. Madam, get the book.
Section 21, my lord, of the NIA Act.
So 30 days is the period for appeal.
Yes.
And another 60 days with condone delay.
yes, Lordship.
So the 90 days.
Lordship, I'd like to submit in this matter, Lordship, that the delay after the expiration of 90 days, whether can it be delayed under the Limitation Act or not in the special NIA appeal, has been already decided by other division bench. Lordship, if Lordship, I submit this, taking I'll submit the citations in the case of Farhan Sheikh versus State National Investigative Agency. The same issue has been dealt in this matter, Lordship, and same issue has been dealt. Whether can be, after the expiration of 90 days can
Where is the previous, where is the citation which you are relying upon?
Oh, yes. Lordship, I'll be relying paragraph 90 in Farhan Sheikh, Lordship. I may read, Lordship.
19.
90, Lordship.
90.
I may read, Lordship. Thus, so far as the constitution of NIA is concerned, it is complete court. However, the same cannot be said about the substantive offences and the procedural laws which would be applicable for the purpose of investigation and conduct of trials of such offences. To the extent that Section 16 of NIA Act prescribes power of a special court, the same will prevail. However, in respect of the matters not there under the Act relating to procedures and the substantive offence, it is the provisions of the code and the substantive law enumerated in the schedule to the Act, which would be relevant, even if the Act is considered to be complete code, insofar as it provides the right of appeal. In the light of the aforesaid discussion, we are inclined to hold that the prescription of limitation in Section 21, subclause 5 of NIA Act is directory and not mandatory, and that the High Court is empowered to entertain and consider application under Section 5 of Limitation Act seeking condonation of delay in filing the appeal. The said application is maintainable, Lordship.
What do you say, sir?
And Lordship, Limitation Act Section 29 clause 2 is clearly stated, Lordship. The applicability of the Section 5 of Limitation Act is excluded when the special law expressly exclude the applicability of the same. And Lordship, there is no such express exclusion of Limitation Act of 1963, Section 29, subclause 2, Lordship, of Limitation Act. May I read Section 29, subclause 2, Lordship? Where any special or local laws prescribe for any suit.
Wait, we'll take it. Yes.
Yes, Lordship. Section 29, subclause 2. Where any special or law or local laws prescribed for any suit, appeal, or application as a period of limitation different from the period prescribed by the schedule, the provision of Section 3 shall apply as if such period were period prescribed by the schedule, and for the purpose of determining any period of limitation prescribed for any suit, appeal, or application by any special or local laws, the provisions contained in Section 4 to 24 inclusive shall apply only insofar as and to extent to which they are not expressly excluded by any such special or local laws. Lordship, what I'm trying to submit it, look, Section 25, Section 21, subclause 5 of the NIA does not expressly exclude the Limitation Act, and the same has been dealt by the Madras Division Bench of Madras High Court, Lordship. Therefore, Lordship,
So Limitation Act will not apply.
the Limitation Act,
Act will not apply
where it
in
is,
view of the NIA Act. In the light of the judgment, the outer limit of 90 days is not correct.
yes,
So
Lordship.
that limitation is there. You are entitled to prefer appeal.
Yes, Lordship. Limitation Act will apply even in the special NIA, Lordship. What I'm trying to submit before this honorable court.
This act will also apply.
Yes, Lordship. For condonation of delay beyond the expiration of 90 days, Lordship.
But the Supreme Court has also taken a different view, saying that if the statute prescribed a particular time,
Lordship, the right to appeal has
so
been,
what you say, sir? Now they say that it is only directory in nature and not mandatory.
My lord, the decision of Delhi High Court, my lord, in my humble submission, when outer limit is prescribed by the statute, my lord. But that is one aspect of the whether delay can be condoned or not, my lord.
So only after crossing this only we can go to the other aspect.
My lord.
right to appeal is vested or accused as a statutory right, Lordship.
This is a High Court judgment. Is there any judgment of the Supreme Court?
This is not yet, my lord. On this aspect, the Supreme Court is not decided, my lord.
Not under the NA Act. Under a different enactment where a statute prescribes an outer limit, for example, commercial division.
My lord, Arbitration and Conciliation Act, my lord.
Arbitration, the outer limit is there.
My lord.
If you take the Payment of Gratuity Act, there also it is there. Unless the NA Act legislatively or borrows or legislative incorporation is there, saying that Limitation Act will be applicable to an NI Act, it cannot automatically apply.
Well,
Yes.
You can see the legislative incorporation. That is not here.
As per
We disagree with you.
As
Take it
per
to the
section
Supreme Court.
29, sorry, section 29, subclause 2, Your Lordship, of the Limitation Act very clearly says that if it is not excluded by any special or local laws, the same will apply. Section 4, section 5 of Limitations Act will
That
apply.
if your argument is accepted, the same principle can be applicable even to the Arbitration Act, Commercial Division, and other cases.
This Lordship, very similar views has been taken by different division bench of a High Court. Lordship, if I take Lordship,
We are not bound to follow. Otherwise, your argument have a persuasive value, but it is not that we should accept it. So we disagree to the view of the Delhi High Court. We'll pass an order, you take it to the Supreme Court. Let the finding be rendered.
and Lordship, in the Madras High Court has also held very similar view.
Madras High Court.
Yes, division bench of Madras High Court. Lordship.
Yes.
Lordship, if I take Lordship to Bahuri, Kitchen Bahuri versus State, I have submitted a citation, Lordship.
Yes. Yes.
Lordship, here this says that a right to appeal is also a
Which paragraph,
right.
sir?
Lordship, I'll take Lordship to paragraph number 17, Lordship. Paragraph number 17, Lordship. Para 17, Lordship. May I read, Lordship? Therefore, the petitioner, appellant, cannot approach
17.
17, Lordship. I may read, Lordship. Therefore, the petitioner, appellant, cannot approach this court under section 439 CRPC as well. In such circumstances, if the accused, for some reason, is unable to file an appeal against the rejection of his bail order or against judgment of conviction within 90 days, and if his appeal is not entertained, it will infringe the fundamental right of the accused, as well as by the Bombay High Court. The reason for the accused not challenging the rejection of bail order on time can be several, such as lack of legal knowledge, lack of financial assistance, or no assistance from any family member or friend to engage a lawyer. No doubt, the right to file an appeal is a statutory right, and the statute can place restrictions. However, it is well settled that the right of appeal from the judgment of conviction affecting the liberty of a person is a fundamental right that has to be read into Article 21 of Constitution of India. In this regard, we may refer to the observation of Honorable Supreme Court in Dilip S. Dahunkar versus Kotak Mahindra Corporation Limited. I may read, Lordship, reproduced 12. An appeal is indisputably a statutory right, and an offender who has been convicted is entitled to avail the right of appeal, which is provided for under Section 374 of Code. Right of appeal from judgment of conviction affecting the liberty of a person, keeping in view the expansive definition of Article 21, is also a fundamental right. Right of appeal thus can neither be interfered with or impaired, nor can it be subject to any condition. The right to appeal from a judgment of conviction vice versa, the provision of Section 357 of the Code of Criminal Procedure, and the provision thereof, as mentioned here above, must be considered having regard to the fundamental right of an accused enshrined under Article 21 of the Constitution of India, as also the international covenant operating in the field. Lordship, right to appeal is also a statutory right, Lordship. And also I take Lordship to paragraph number 23, Lordship. Paragraph number 23, Lordship.
Paragraph number
23, Lordship.
20?
23. 23. Unread, Lordship. Thus, in a case of this nature, where a provision or in the procedural law has the effect of extinguishing a fundamental right, we may read down the provision. If the petitioner appellant is denied his right of appeal, in spite of showing sufficient cause for the delay in filing the appeal, it will be denying his fundamental right, which cannot be permitted by any court, much less a constitutional court. Therefore, we are of the view that the second proviso to the Section 21, subclause 5 of the NIA Act has to be read down. The word shall be read as may in respect of appeal, which, if not entertained, would amount to a violation of fundamental right. The appeal challenging the judgment of conviction and the appeal challenging rejection of bail, in our view, we are filed in exercise of one's fundamental right. The other appeal that we can think of which would involve the fundamental right of an accused is against an order of cancelling his bail. Therefore, in those type of appeal which are filed with a delay, the word shall be read as may. As 24, Lordship. As stated earlier, we are doing so notwithstanding that there is no challenge to this provision. Firstly, because the Honorable Supreme Court in Kailash case laid down a provision relating to restriction of filing the written statement.
What do you say?
My lord, as far as
Any provisions of the Act
my lord,
cannot take away the rights guaranteed in the Constitution. Right to life, 21.
my lord.
Though we may not agree with the views expressed by the bench with regard to the civil procedure code,
My lord.
where the right will have to be determined.
My lord.
Here, the honor of a person needs to be considered. For example, as I said earlier, Provident Fund Act, EPF Act,
My lord.
ESA Act, Arbitration Act, Commercial Division, everything has got a time limit. In fact, sitting singly in Madras High Court, I have also read a judgment that beyond 90 days, your rights are extinguished.
Yes.
You have no right. But the same principle cannot be applicable pertaining to a criminal matter where the life of a person will condone the delay. He'll condone the delay. He'll pass a detailed order, thereafter number it and take it up.
My lord, there are two aspects, my lord. One was whether delay is at all condonable or not, my lord. The second aspect is whether he has made out sufficient cause for condoning the delay, my lord. So, my lord, the lordship permit me to address that second aspect, my lord, that he has not made out the
In
case for
criminal
condoning.
matters, there are so many cases where even 3,000 days, 4,000 days delay and all is automatically condoned.
Why, my lord? Why, my lord? He earlier approached this honorable court, my lord. He withdrew that application, and thereafter there is delay, my lord. Lordship kindly takes up his application. He is mentioned there, my lord.
Where is it?
Yes. Lordship, earlier the bail application was filed before the Honorable High Court. The same was approached with wrong provisions. Therefore, it has to be withdrawn. Due to wrong provisions in the bail application, we have to withdraw those. And we have,
Right, you approach and thereafter also there is a delay. That's what he says.
Lordship, the delay is from the date of the impugned judgment, Lordship, passed by the special NIA Act. Lordship, here what happened in this matter, Lordship? Lordship, the accused is under incarceration in judicial custody. He has to fully depend upon the family members to file any petition on his behalf. And Lordship, the family members deriving from a poor family, moreover illiterate, Lordship. After multiple unsuccessful bail
How
applications,
many days delay?
113 days delay. 113 days delay, Lordship.
113.
113 days delay.
My lord, why I am pointing out this, my lord? If lordship kindly takes up page 3 of his condonation application, my lord.
Page 3.
My lord.
Yes.
At page 3 is given a table, my lord.
Yes.
My lord, 21/8/2023 was the impugned order passed, my lord. Then he filed, bail application was filed on 25/9, my lord. Before this honorable court, bail application number 48 of 23. That was withdrawn on 28/9/23, my lord. With liberty to file afresh. And then he takes, my lord, about little less than 3 months, my lord, to file the fresh bail application, my lord.
So we'll pass orders on this. We'll accept the reasons given by him, we'll condone it. We'll pass a detailed order.
My lord.
Pass orders. Orders on Monday.
Okay.
Orders reserved.
Yes, my lord.
In the applications.
My lord.
Deeply obliged.
Today you're here. Tomorrow you may be on this side also.
But that's true. Yes, my lord, since the matter your lordship kept reserved, may I place 1 or 2 judgments supporting my case or for some other high
If
court?
it's available, you circulate it.
My lord. I'll give to the court master, my lord, in the
See,
court.
though I agree with you on principle.
My lord.
But we agree that the Limitation Act cannot be pressed into service when the Act, the subsequent enactments specifically exclude
The outer
or
limit.
not include the Limitation Act. But however, with regard to when Constitution, rights is
Right,
there,
comes
it
into play.
has got to be,
My lord.
yes.
Deeply obliged.
Item number 5.
In this matter, I am required to file an additional affidavit, my lord. Certain documents were missed out while filing this present petition, my lord.
Yes,
I am praying for some more time, my lord.
How much?
3 weeks time, my lord.
3 weeks. The request of.
I have no objection, ma'am. I have no objection.
Yes, sir. At the request of
have no-
India, at the request for Council for Union of India, post the matter after 3 weeks for filing an additional affidavit, my lord.
Deep.
Obliged.
Item number 6.
How many cases? 6, sir. Respondent here. 8.
Please, Your Lordship, I'm supposed to file an affidavit in this matter. I just would like to seek another 2 weeks' time. There's a,
Yes. At the request of the writ petitioner to file an additional
and
affidavit.
the respondent, Your Lordship.
So you want to file an additional affidavit?
No, I want to file an affidavit in response to the writ petition.
You want to file an objection to his affidavit?
Yes, Your Lordship. And respondent number 4, 5, 6, and
At the
7.
request of the respondent 4, 5, and 6. 4 to 6
4, 5, 6,
for
7.
filing a reply
The reply.
or counter, whatever it is. Post after 2 weeks.
2 weeks.
Obliged.
Much obliged, Lordship.
Item number 7.
What state is it?
Maybe please, Your Lordship. As per order dated 31/2024, this also notified it.
Sir?
And they have notified, the notification supposed to be correctly issued, and they have done it.
No, Lordship, if I may just assist the court, Lordship.
I'm Joint Secretary of so and aware of the facts and so on, and competent side of it, and court. Well, discussing the government right to vote, direct message of it.
Here, Lordship, if I just assist the court, if Lordship, I can take it, Lordship, to the order of 19/10/2023.
1910?
2023.
Nineteen ten, 2023.
23, Lordship. Lordship, the first paragraph is relevant, and then first paragraph and the para 7.
1 minute, 1 minute. Yes, 19/10/2023. Yes.
Lordship, the first paragraph, if I may read, Lordship. The state refers to a recent notification, August 25, 2023, copy whereof has been appended to the state's latest affidavit of the October 19, 2023. So, Lordship, what happened was we had filed an affidavit, but the court observed in para 2 and 3, Lordship, that there could have been some mistake and we have not fully applied our mind.
On the state refers to regulated zone, regulated from Meghalaya, water bodies, the definition regulated indicates a construction of building and those sectors regulated zone will be para 5 and the guideline. Well, para 5 regulation has nothing to do with the regulated zone. It's referred to only in the guideline hardly prepared a mistake indicate that they may not be in full application of mine.
And para 6, Lordship? Important.
Para 6.
Para 6.
The regulation appears to contain obvious mistake need to be corrected. The matter will stand over for 4 weeks. Now we have done it.
Lordship, on the last date, Lordship, we said we had made a submission in the court that we had corrected it. It was pending only approval. So today we have filed a status report, Lordship, that has been approved, and the corrected affidavit we have filed.
Then we can close the petition.
It's a PIL.
It's a PIL. A PIL. This is regarding the water body. Water
I
body.
may also draw your lordship's
Para
attention to
7.
the para 7.
Para 7, Lordship.
Paragraph number 7 of the same order.
Same order.
Same order.
Because what had happened is there is an injunction against me, respondent number 4 and 5, till this matter was finalized by the state. Now that the state has finalized it, the set-off is laid out as 3 meters and 6 meters. My set-off is, 980 meters and 470 meters respectively. So way beyond, what is the required set-off under the law. So I would only pray before your lordships, that your lordship, the injunction as against me may kindly be vacated.
Lordship, I appear for the respondent number 6.
See, now the interim order is that till the guidelines are formed. Now the guidelines have been formed and notification has been issued.
There is an order which says without the express leave of this honorable court, that the injunction may not be vacated. I'll just take your lordship's notes.
The subsisting injunction will continue to be in place till such time the guidelines are finalized and accepted by the court.
If I may draw your lordship's attention to order dated 24/5/2023 means.
24th?
5/2023. Is the earlier notification said 50 meters, That's where the honorable court had observed that without the
No,
previous.
we will say, let the notification be part. That is fine. We will give you liberty if you are aggrieved.
No, I'm not aggrieved, because admittedly I am 980 meters and
Then
400.
leave it as such. That is all. The persons who are aggrieved can knock at the doors of the court.
Yes.
Now it's a
Injunction is only
issue has been taken by this court.
The injunction is solely as against respondent number 4 and 5 only, because they were the two constructions that were coming up in that area.
Please, Your Lordship. Lordship, I appear for the respondent number 6.
Sir?
I appear for the respondent number 6.
Respondent number?
6.
6.
Your Lordship. So my only submission at this stage, Your Lordship, is this matter can come up after 2 days. I'll take instruction to these guidelines. Because it was one of my objections that these guidelines were again reframed or amended, Your Lordship. Paragraph 4 and 5 was my objections to the order dated 19/10/2023. On the basis of my submissions, the guidelines now have been amended. I have been served with a copy this morning itself, Your Lordship. So I just need 2 days. I'll just take instructions from my client.
You want time?
Your Lordship.
When the matter is taken up for hearing, status report has been filed by the Joint Secretary to the Meghalaya, also the department.
No one was there.
And submitted that the error that was crept in the earlier notification, earlier report has been rectified, notification has been rectified, and correct notification has been duly approved and republished on 13/2/2014. The counsel for the sixth respondent would submit that based on his objection, the fresh notification has been published and that he has been served with the copies only this morning and seeks 2 weeks' time.
2 days, 2 days, my
2
lord.
days' time. I request 2 days' time to report before this court. Call the matter on Monday.
Monday next.
Lordship,
Lunch.
just like to intervene. I'm representing the Kasils Autonomous District Council, which is respondent number 7. We would also like to have a copy of the proposed whatever the guidelines.
6 and 7.
Oh, no, okay. Lordship, right.
Come back to your lordship.
You need not represent in installment.
Obliged.
Thank you.
Item number 8.
Please give us a copy.
Oh, sure.
Please, Your Lordship. My Lord, I am seeking a small accommodation today, my Lord. My Lord, my colleague is arguing this matter. She's on leave. My Lord, if the matter can come up on Monday.
Who is on leave?
My Lord, one of my colleagues was arguing the matter, my Lord. I slightly handicapped. I'm not well aware about the brief. I'm praying time only till Monday, my Lord. Short accommodation.
Can it be Can it be taken up on Tuesday, my lord?
Monday or Tuesday.
At the request of both the parties, list the matter on Tuesday.
Much obliged.
Obliged.
My Lord, the report is also to be filed.
My lord, the report has been filed. No, my lord, report is ready. I'll file it today. My lord. Please represent me. You are appealing the respondent. I'm for the state respondent.
I'm for the appellant, my Lord. He's for the respondent.
Yeah, that's it. My lord. The respondent will submit that report has already been filed. No, my lord, it will be filing today, my lord, in the course. The respondent will submit that the report will be filed today. When pursuant to the orders of the date, pursuant to the orders dated 6/2/2024, the additional report is made ready and the same will be filed today. My lord. Call the matter on Tuesday.
Much obliged.
To serve copy in advance. Yes, my lord. Very nice court hall. A nice court hall, and all the advocates are sitting from the second row and allowing the counsel who is addressing to come to the front. The two things I'm not able to. One is I'm not able to follow your pronunciation. That's one problem. Not all. Some pronunciation I'm not to follow. The other one is sometimes it's not audible. These two things I'll have to. You have to sometime know. We have to speak more closely to the mic. My brother says that you have to speak very, the mic should be very close to
Yes, my Lord. Otherwise, some of us are quite loud, my Lord. Not all of us. But if we use the mic, then my Lord, it's very audible. We have a very good sound system in the courtroom room also, my Lord.
Yes. Yes.
Much obliged.